As we mentioned, the Arizona Supreme Court today heard oral arguments in a case in which the justices will decide which of two abortion laws on the books will be the law of the land. We're joined now by Andy Gaona. He argued the case before the Supreme Court today as the legal counsel for Planned Parenthood Arizona. So we appreciate your time on this very busy day, Andy. Thank you so much for being here. For those who aren't totally up to speed on the case, what did the justices hear today?
So today, the justices were considering a petition for review filed by the interveners in the case, Dr. Eric Hazelrig and Yavapai County Attorney Dennis McGrain, who want the Arizona Supreme Court to reverse what the Court of Appeals held last December, which was that in Arizona, physicians who perform abortions up to 15 weeks LMP in compliance with a law passed in 2022 cannot be prosecuted under what we call the territorial ban that you mentioned just a moment ago. The law first enacted during the Civil War, which criminalizes essentially all abortions in the state.
Your argument that the recently enacted law supersedes the pre-statehood law, what is that? What argument did you make today in front of the justices?
Well, the argument we've made all along is that there is a fundamental conflict between an old general law that criminalizes a certain class of conduct, here performing an abortion, and a newer, more specific law that allows doctors to perform an abortion up to 15 weeks. And so in the case, when you have two statutes that conflict like that, courts have to do what they call harmonizing those two statutes. That's what the Court of Appeals did in reaching the holding I mentioned earlier, under which physicians who comply with that law cannot be prosecuted under that territorial ban.
How does, harmonizing the law, we see that a lot in stories about this particular case, and we hear about it a lot. When you harmonize, it sounds like both parts are at play. What part of the older law would be at play under this harmonization as it exists by way of the appeals?
So in 1973, the Arizona Court of Appeals and ultimately a Pima County Superior Court judge held that the territorial ban was unconstitutional as to all. What the territorial ban criminalizes is essentially anybody who helps to procure a miscarriage, is how the statute is phrased. It's very, as its vintage suggests, it's an old-timey phrase. And so what we've argued all along is that the territorial ban remains in effect, it's still on the books, and it can be enforced against anybody who is not a physician who procures a miscarriage in violation of the provisions of the territorial ban. The problem, of course, is that there are providers of abortion services in Arizona who, after the Dobbs decision came out from the U.S. Supreme Court, were put in an incredibly difficult position, who were having to call their lawyers before providing health care to pregnant Arizonans who were seeking out their care. And that's exactly why, when the former Attorney General sought to lift the injunction against the territorial ban in its entirety, Planned Parenthood said, not so fast. You have to account for 50 years of legislation that has happened since this ban was first enjoined.
And yet the other side will argue, and no doubt did today, that it was illegal prior to Roe. It should now be illegal now that Roe is overturned. How do you respond to that?
My primary response to that is ultimately a policy question for the policy-making branches of government to decide. And if the legislature truly wanted the territorial ban to be resurrected in its entirety and to supersede all of the legislature's enactments regulating abortion over the past 50 years, then it should have done so clearly and expressly. And the fact of the matter is that the legislature didn't do so. And as I told the justices this morning, there's a pretty good reason for that, which is that the legislature didn't have the votes. And it's not the court's job to try to fix a problem of the legislature's making here.
So when the other side says that the old law, it's never been repealed and it's never been amended, which suggests that the legislature and lawmakers didn't want this to entirely go away, how do you respond?
I agree, Ted, that the territorial ban has never been repealed, either directly or impliedly, but statutes can be amended impliedly. And while the legislature had some language in the 15-week law that said, we do not intend by this act to imply to repeal the statute, It did not say that a subsequent statute couldn't amend 3603, which is the territorial ban. It also didn't say that a subsequent statute couldn't limit that statute. And our argument is that that's exactly what the 15-week law passed in 2022 did. It created a new set of permissions for physicians to perform abortions within the confines of that statute.
And real quickly, because you broke up a little bit, and I want to make clear on this new 15-week law, basically it specifically said it did not repeal the territorial law. And again, your argument was, we kind of lost you a little bit on that one.
I'm sorry about that, Ted. My argument was that it's true that the territorial ban was never repealed, but nothing that the legislature put into the 15-week law said that that the territorial ban could not be impliedly amended or limited by the 15-week law. And that's exactly what the 15-week law did.
What's next in this case? What kind of timetable are we looking at?
So now, Ted, you're asking the question that all my clients ask after an argument like this. When are we going to know what happens next? And at this point, the court has taken the case under advisement. They'll issue an opinion, as they like to say, in due course. And in my experience, that could be in 1 month. It could be in 1 year. We have no idea. But what I do know, and what should be clear, is that while we wait for the court's decision, the 15-week law remains in effect. Planned Parenthood is providing abortion services. Other providers are providing, and it's now a waiting game.
And real quickly, as far as the way you see this, what's at stake here?
What's at stake is the ability of pregnant Arizonans to seek out necessary health care. If the Supreme Court were to reverse the Court of Appeals decision and the territorial ban were to become fully enforceable, it will have a severe chilling effect, not only on physicians, but also on the pregnant Arizonans who would seek those physicians out for their care. That's a dangerous world to live in. And I think we just saw a recent example in Texas about the tragedies that can happen when you have total bans in place.
And real quickly, before we go, it's just procedural. It's just my curiosity. I find this fascinating. How long did you speak before the justices today?
So our side of the case had a total of 30 minutes. I think I was up there for about 14 of those 30 minutes, if my math was correct. I'm happy to still be talking about the case. I think it was a good day for us. We feel confident that the Supreme Court will do the correct thing and affirm the opinion below and affirm that Arizonans do have access to abortion up to 15 weeks.
Andy Gaona, legal counsel for Planned Parenthood Arizona. Andy, thank you so much for your time. We really appreciate it.